Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, this is going to be about House Bill 1143. Some big, huge announcements. Actually, some good news for once. As you can see, we are coming to you from our central Washington location here in beautiful Cle Elum, Washington. That's the Teanaway River right back there. But listen, I get that this legislative session has been bad news after bad news after bad news. I'm happy to announce that there's at least a little bit of good news as it relates to House Bill 1143, Washington's pre-purchasing license requirement. So today, let's spend a few very important minutes, get you all educated, and talk about the huge changes to Washington's pre-purchasing licensing bill. Okay, so like I said, what we're going to be talking about today is House Bill 1143. Now, before we get too far into that, let us all remember, and this is important, we did this video about it right here. Thursday, March 23rd, 8 a.m., there is a huge hearing before the Senate Law and Justice Committee in Olympia. House Bill 1240, the assault weapon ban, as well as 1143, the bill we're going to be talking about today, are both slated for public testimony. We have already given you all the information. We will give it to you again in the links down below on this video on how to testify. Very, very important. It is our last stand. What we're going to be talking about today is House Bill 1143, Washington's pre-purchasing licensing requirement. Now, I have mentioned about and spoken about this before this bill ever dropped, and I told you what an absolutely offensive and horrific piece of legislation this was. There have been significant changes to this legislation, which means it is now no longer the most horrible piece of legislation I've ever seen, but it still is pretty bad. What are the big changes? Well, I have both bills here. This is the original bill. The original bill was 72 pages. This is the engrossed substitute bill. It is 18 pages. So anytime a bill goes from 72 pages to 18 pages, we are certainly moving in the right direction. The big difference, and this is a huge difference, is under the old bill, we would have had to go get a license. That's right, an actual license that the state could deny us. We would have to go through a licensing program, a mandatory educational program, and then we would have to pay the state for a license, a permission slip, before we could go exercise a constitutional right. And I think we can all see what the problems with that is. And obviously all you need to do is just buy a gun out of there and put any other inalienable right or so-called inalienable right there. And you can see that at no point are we required to have a license to do that. Okay, this has been a subject of a lot of debate, primarily down in Oregon lately with Oregon Ballot Measure 114, and it has proven to be, or their attempt to implement it has proven to be, an absolute unadulterated disaster. What does the new version of 1143 require? The new version of 1143 does not require that you get a license. Instead, it requires that you complete a mandatory safety class. It is very similar. In fact, those of you who are familiar with Initiative 1639, you will see that the curriculum between what we are required to take in 1639 safety classes and what will now be Washington's new pre-purchasing safety class are almost identical. And I can assure you that neither one of them are going to probably do anything to save lives. Now, under the new legislation, the class that you will need to take in order to receive a certificate that you must show then to buy a firearm shall cover the following curriculum. A, basic firearm safety rules. B, firearms and children, including secure gun storage and talking to children about gun safety. C, firearms and suicide prevention. D, secure gun storage to prevent unauthorized access and use. E, safe handling of firearms. F, state and federal firearms laws, including prohibited firearms transfers and locations where firearms are prohibited. G, state laws pertaining to the use of deadly force for self-defense. And H, techniques for avoiding criminal attack and how to manage a violent confrontation, including conflict resolution. Now, I think that we can agree that all of those subjects are very valuable subjects, and whether or not a person should be mandated to educate themselves before they exercise an inalienable right, I think is a question that the courts will still need to decide. Clearly, most of our voters do not educate themselves, and many of you do not read the voters' pamphlets, so we are certainly not requiring any type of educational requirement before people go and punch their ballots. Now, here's the big subtractions from the new bill now. Number one, we're only needing to take a class rather than get a license, which means it significantly cuts the cost, cuts the bureaucracy, and cuts the red tape necessary in order for us to secure what should be an inalienable right. The other thing is that the original bill required a live attended class, including the following: live fire shooting exercises on a firing range that include a demonstration by the applicant on the safe handling of and shooting proficiency with firearms. And again, I am all for training, and we preach that here all the time at Washington Gun Law. But the requirement you have to demonstrate proficiency and then get a permission slip before you exercise an inalienable right is not how things are supposed to work in the American system. Now, I'm not suggesting for one second that 1143 is a worthwhile piece of legislation. There are still some huge problems. As a matter of fact, if you take a look at all the data that's collecting, and they make no bone about it, they are absolutely, positively, and without a doubt establishing an unlawful gun registry here in the state of Washington, which would be violative of the Firearms Owners Protection Act of 1986. In addition, anytime you give them an inch, it's only a matter of time before they take a mile. And so while this may seem as an innocuous educational requirement, it would only take mere tiny pieces of amendments to this particular legislation to start adding unnecessary costs or other mandates, so that what starts as an innocuous piece of legislation in 2023 makes it literally an absolute barrier to exercising a constitutional right by 2028. And that, my friends, is part of the game plan here. So the bottom line is this: 1143 in its new engrossed substitute bill is in a much better condition than when we started. It is still not a good piece of legislation, but it's not an absolute pile of crap that it once used to be. Remember, we're going to have a public hearing on this bill, and we're going to have a public hearing on House Bill 1240 Thursday the 23rd at 8 a.m. before the Senate Law and Justice Committee. We need all of you there. This, in many ways, is our last stand. Listen, if you have any more questions about House Bill 1143 or anything else that might be related to what's left of our Second Amendment rights, you guys should know the drill by now. But if you don't know how to contact Washington Gun Law, well, all of that contact information is in the description box down below. In the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, from Cle Elum, Washington, thanks for watching, and stay safe.